Okay. Greetings, everyone. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. We're going to make this short tonight because I've got a specific intent in the video tonight as it relates to recent actions at the local district court as it relates to Andrea Dreyer. This is in no way meant to do anything detrimental. It's merely a matter of correcting things as I see them through my research. And hopefully I'll be able to present this short video to her and she will accept it to see what I'm talking about. So we're going to get into it right away with the bench warrant. As you've seen before in previous video, where we discussed this civil case 144311. And let me make sure this is full screen. And like I said, this is the original bench warrant, Iowa Courts Online electronic docket. And this is one of the things she mentioned, that it was an electronic bench warrant. And as we see under the summary, it says title, in the matter of the jury service of Keith Little, and it's got the case number. And originating county is Black Hawk, and therefore they must be the plaintiff. 12/21/2021. And it says disposition status. No disposition records were found. And as far as I know, what they're talking about here would be the state's minimum contact requirements. And like I stated in court on Wednesday, I'm not qualified for jury duty, not just simply for the being a felon and not a registered voter, but for multiple other reasons, of which we'll go over. I've got to pull it up here real quick too. Reminds me. Let's see, Iowa. Jury duty. See if I've got it here. Maybe it's under questionnaire. Okay, I think this is it. Yep, got it. Okay, we got that one pulled up. So let's continue on with this. And before we do, I want to remind everybody, please hit that like, share, and subscribe button and on any of the three channels, and get this information out there. Just a matter of doing your research so you can do some interpretation. And so no disposition records were found. And that relates to like driver's license. Haven't had one of those since the last trial 7 years ago, suspended, never renewed it. I'm not a resident of the state of Iowa by definition, either by the Iowa Code or the federal code. Iowa Code, the resident determination is for an income tax purposes. And you already know the resident one for the federal code, which I'll remind you here in a minute. But for that Iowa income tax purposes, I haven't had a job for 7 years either. I haven't had any bank accounts for 7 years either. So the minimum state requirements as regards to the disposition records, I believe that's what they're looking for, minimum state requirements. The next one is the financials. And you'll notice that under the financials, it's got the case number and the title and everything. Again, it's got a summary of the costs, fines, surcharge, restitution, and other. Original, paid, and due, and everything is zero. Zero. So there's zero consideration at this point. Then we go to long title. And it says long title in the matter of the jury service of Keith Little. case number, citation number. And notice there's no citation number. There was no citation issued either. Original instrument, of which a financial statement is supposed to be attached, I believe. And it says no long title found. So if there's no long title, then maybe there's a short title. Either way, they're depending upon a title. Bonds. Bonds posted in the matter of jury service Keith Little. Case number, citation number, nothing. No bonds found. And then we're going to take a look at filings. But before we do that, there's this little one over here. It says criminal charges disposition. Okay. And remember, we saw in the original summary, the disposition, there is no disposition records found. And it's going to tell us charges, disposition, sentences in the matter of jury service of Keith Little, case 01071, case or citation number, nothing, and no charges found. So we've got a civil case with no criminal charges found. And yet, under the filings, they've got application initiate contempt, show cause civil, failure to appear for jury duty, and then it says order to show cause, jury contempt 2/9/22 at 1:15 p.m., copy to Blackhawk County Sheriffs to serve defendant. So now we've got somebody that's supposedly involved in a contract, a civil issue, which is a contract issue that is now being named a defendant. Yet they had no service, return of service, diligent search. And we even spoke about that. They couldn't serve me because they didn't have an address. And then when I gave her an address in the court to send me another summons for jury duty, I gave her a care of address. So if they do send me a summons for jury duty, then I'll have to look at the address and see if she wrote it down correctly as I gave it to her as a witness. See, I'm not a defendant. The defendant has to voluntarily appear in court, folks. And we're going to show you that here in a minute. And the state or the plaintiff has to provide service, has to serve the defendant in the state in which the court sits. And I'm not registered on the electronic stuff, so they couldn't serve me there. And they didn't have the physical definitive paper address to send it through the mails, so they couldn't serve me there. So there was no waiver of personal jurisdiction form sent so that I could voluntarily appear in court by waiving said personal jurisdiction. Order to issue public bench warrant, bond set at $350. So it seems we have a plaintiff called Blackhawk County that can't appear in court, and there is no financial statement backing it up. Yet somebody set a bond for $350, naming a defendant. And then when I went into court on this last Wednesday, we cleared up the issue on the bond being dismissed and that she would send me another summons. But what we have, you notice it's D0004, order to issue public bench warrant. She did not enter in D0005, which would be the dismissal of the bond, but instead enter D0006, order for continuance. Continuance of what? Because as far as the material facts on the record point out, there still is no personal jurisdiction granted to the court. It cannot be assumed. Particularly in matters of probate estates, wherein the courts have no jurisdiction over the estate of a person who is in fact alive. Scott versus McNeil. Very succinct. I do have a living will and a living trust, and it's based on the word of our Father which art in heaven. Hallowed be thy name. Lead us not into temptation, but deliver us from evil. So let's look at the next thing, which is personal jurisdiction under LII Wex, Cornell Law School, Legal Information Institute. Personal jurisdiction overview. Personal jurisdiction refers. It's just a reference. There is no authority for personal jurisdiction as far as I know. It's a reference to the power that a court has to make a decision regarding the party being sued in a case. Before a court can exercise power over a party, the U.S. Constitution requires that the party has certain minimum contacts with the forum in which the court sits. This is going to be restated. International Shoe versus Washington, 326 U.S. 310, 1945. So if the plaintiff sues a defendant, that defendant can object to the suit by arguing that the court does not have personal jurisdiction over the defendant. Waiving personal jurisdiction. Personal jurisdiction can generally be waived. Contrast this with subject matter jurisdiction, which cannot be waived. So if the party being sued appears in a court without objecting to the court's lack of personal jurisdiction over it, then the court will assume that the defendant is waiving any challenge to personal jurisdiction. I'll have you know, I told her I was not qualified for jury duty. That was my objection to everything. Personal jurisdiction, because I'm not qualified. If I'm not qualified as a person regarding the subject matter, then that disqualifies the subject matter. And if you bring that subject matter in a territory of the United States under special maritime territorial jurisdiction, then the United States is most certainly involved. And when I explain that I'm not qualified, then there is a diversity of citizenship implied. Just because you don't catch that or don't infer it because I didn't refer specifically to it doesn't mean it's not there. Personal jurisdiction. So if the party being sued over it, then the court will assume that the defendant is waiving any challenge to personal jurisdiction. You cannot assume it if I already did object to the qualifications. See Federal Rule of Civil Procedure 12b-2. You can look at that all you want. Obtaining personal jurisdiction. Obtaining so that you can sustain and maintain. Typically, for a court to have personal jurisdiction over a defendant, the plaintiff needs to serve the defendant in the state in which the court sits. The restatement of what we just read above in regards to the United States. This is Diplomatic Channels of Notice, 22 CFR 93.1. And the defendant needs to voluntarily appear in court. Andrea Dreyer, if you think that the living soul that showed up in that courtroom as a first-hand witness is a defendant, I would have to ask of your competency of understanding the English language. Defend ant is a third person abstract noun meaning total fiction. I assure you, any English major will agree. This is because the individual, which we'll read about here in rule number 4 in regards to that summons that you agreed to send me for jury duty, but instead put on the record a continuance of the summons that wasn't served to begin with. The individual's name and number identify the record. 20 CFR 402.103. Employee benefits. That's the Social Security number and the name on the Social Security card, and they identify the record. Needs to voluntarily appear in court. I don't know if a third-person abstract noun can do that. It's an impossibility. It must be dragged into court or pulled from a file or a record or a bureau or a drawer or a closet or somewhere. It's a piece of paper. It is not myself. I am the living soul. Federal Rules of Civil Procedure, Rule 4K, describes whether a state's courts would have the authority to adjudicate a claim as it relates to personal jurisdiction. Rule 4, summons for jury duty. A summons, contents, a summons must name the court and the parties. So again, the individual named on the summons has a number, and the name and number identify the record. Not me. Okay? Let's make this very clear. Be directed to the defendant. And again, the name and number identify a Social Security record, so it needs to be directed to the Social Security Administration. I cannot place a liability on the public record. I am not qualified. Be directed to the defendant. State the name and address of the plaintiff's attorney, or if unrepresented, of the plaintiff. I didn't see an address. State the time within which the defendant must appear and defend. I didn't see it. I'm not a witness to that. Notify the defendant that a failure to appear and defend will result in a default judgment against the defendant for the relief demanded in the complaint. Okay? So again, if the Social Security Administration is the holder of the defendant, it needs to be directed to them, and they can file for that judgment. I don't qualify. I don't have a board of directors that can hire an attorney to represent me in court. A requirement under Texas Rule of Civil Procedure 12. Even as a president of a company, I couldn't hire an attorney myself. That's something that has to go through a board of directors. Be signed by the clerk. Bear the court seal. I don't know if the electronic seal is worthy of the proper adjudication. You would have to clarify that. Amendments, the court may permit a summons to be amended. Issuance on or after filing the complaint. See, it seems to be the summons for jury duty is the summons on a complaint. That's what it would seem. The plaintiff may present a summons to the clerk for signature and seal. If the summons is properly completed, the clerk must sign, seal, and issue. So you have a judge that orders and the clerk that issues. So we have an administrative law judge and a judicial officer. And they're playing with Postal Service contracts under the Judicial Officer Department, where that's where you get the authority to adjudicate, is a neutral and independent forum within the United States Postal Service, comprising of the judicial officer, the administrative law judge, and the Postal Service Board of Contract Appeals. This is why that address is so important. And I gave you a care of address. And you'll notice the one that I named in care of there was just Joyce, a given name, and no last name. And that is mine companion, mine wedlock. And there is no law that allows for the separation of me and mine companion. Even your bench warrant, if you could enforce it, violates the natural law. The clerk must sign, seal, and issue it to the plaintiff for service on the defendant. Now we have the clerk that issued it to the Black Hawk County Sheriffs. So we have a plaintiff known as the Black Hawk County, and the clerk that signed, sealed, and issued the order that was given by the judge, and it was served to the Black Hawk County Sheriffs, issued to the plaintiff for service on the defendant. It was issued to the Black Hawk County Sheriffs. So who is the plaintiff, the Black Hawk County or the Black Hawk County Sheriffs? Issued to the plaintiff. See, the Black Hawk County Sheriff himself is an elected man of the people, and the sheriff's deputies are hired by the prosecuting attorney and the county commissioner. That's my understanding. Those are contracts. The sheriff is operating as public servant in trust, as well as all the other people in those contracts. They're also public service contracts, so they too deal in public trust. A summons or a copy of a summons that is addressed to multiple defendants must be issued for each defendant to be served. Service, in general. A summons must be served with a copy of the complaint. The copy of the complaint served with a jury summons would fail that, because when they send you a copy of the summons for jury duty, there's no complaint on there. So is the summons for jury duty really a legit document? I question these things. I don't know the law, but the way this seems to work, it's supposed to have a complaint attached. It's called a summons. The plaintiff is responsible for having the summons and complaint served within the time allowed by Rule 4M, and must furnish the necessary copies to the person who makes service. I don't make service. The service is already provided. I'm the benefactor, not the trustee, not the grantee. Benefactor to the beneficiary, giving the data elements to the record that Social Security holds as the benefit for those involved. However, my misunderstanding is that I haven't been in the right capacity all my life, and everything I've been placing in as data elements has been placed as a liability on the public record due to continuous and repeated exposures to the same events that cause that liability on the public that I never expected nor intended. That would be accidents. And then, of course, on the other side of the counter, mistakes were had because of my own actions. I repent for those. And if you find any more, I'll repent for those as well. But this is a matter of correcting the records that were established that we all have fault in. And I'm providing for a redemption so that no person shall be held liable in any court in the interest of the United States, for the account of the United States, and for the person making the same. Moi, the benefactor to the beneficiary. This is full acquittance and discharge. It is a method of payment. 31 CFR 315.35. Not sure on that, but it's close. I can always look it up if you need to. So then the next one, it says, by whom? Any person who is at least 18 years old and not a party may serve a summons and a complaint. Now, this is a summons and complaint. However, is not a party may serve a summons. So the summons is served by who? Andrea Dreyer, as a judge in Black Hawk County Court, you are a party to the serve. You are a party to those courts. You can't serve that summons. You can't be the plaintiff. And you can't make a complaint that I didn't appear on your presumption. Be a marshal or someone specially appointed. At the plaintiff's request, the court may order that service be made by a United States Marshal or Deputy Marshal or by a person specially appointed by the court. The court must so order if the plaintiff is authorized to proceed in form of pauperis under 28 U.S.C. 1915 or as a seaman under 28 U.S.C. 1916. Now, why would somebody as a person so authorized be poor? Proceed in form of pauperis. I don't know why they mentioned that there, and I really don't care. The point is, the court must so order if the plaintiff is authorized to proceed in form of pauperis, specially appointed by the court. United States Marshal or Deputy Marshal or by a person specially appointed by the court. I don't know that the sheriff is specially appointed by a court. He's elected by the people. Waiving service. This is the interesting one. Requesting a waiver, an individual, the individual's name and number identify the record. So the name and number that you're looking for identifying a record is asking for a waiver of the record. Again, you have to ask that of the Social Security Administration. I have no records. I carry no identifications. I don't have a driver's license. I've got a bicycle driver's license if you want to see that. It's very comical. I don't have a state ID. I don't have a fishing license. I don't have a hunting license. I'm not qualified for those things. Be in writing and not electronic form. To the individual defendant, again, Social Security Administration, not me. For a defendant subject to service under Rule 4H. To an officer, a managing or general agent, or any other agent authorized by appointment or by law to receive service of process. See, I, as the man in physical form, am not qualified. I'm not qualified for business or trade or the functions of public office. Name the court where the complaint was filed. And again, we see the plaintiff is the originating county, Blackhawk, and that's where the summons was filed. And yet there's no complaint except an issue to show order to cause by a party to Blackhawk County Court. An appointed judge. C, be accompanied by a copy of the complaint, 2 copies of the waiver form appended to this Rule 4, and a prepaid means for returning the form. The prepaid means is that little envelope that says return envelope, postage not required if mailed within the United States. Again, very important for that address, because in the United States, where is the United States? See, the states ceded their jurisdiction to the United States. And for civil actions, which are commercial contracts under UCC 9-317, the location of the debtor, known to be the United States under subsection H, it says the location of the United States. United States is located in Washington, D.C., and Washington, D.C. is defined by the 10 square mile boundary And the United States, therefore, is the record containing the name and number of all those individuals, corporations, and all of that. Corporation or association. An association is those minimum state contacts. I'm not associated with the state. I'm associated in trust as the benefactor for your public service of public trust, of which is an extension of the Global Postal Trust Services. And that's why the United States Postal Service is the registered agent. And the Judicial Office Department is the independent and neutral forum within the United States Postal Service. Again, comprising of the judicial officer, the clerk, the administrative law judge, you, that works for the judicial branch, adjudicating cases, and the Postal Board of Contract Appeals. Inform the defendant using the form appended to this rule of the consequences of waiving and not waiving service. State the date when the request is sent. Give the defendant a reasonable time of at least 30 days after the request was sent, or at least 60 days if sent to the defendant outside any judicial district of the United States, to return the waiver and be sent by first-class mail or other reliable means. Failure to waive. If a defendant located within the United States fails without good cause to sign and return a waiver requested by a plaintiff located within the United States, the court must impose on the defendant the expenses later incurred in making service. See, when I appeared in court the other day, it was not making service. I'm not qualified. I told you that. The reasonable expenses, including attorney's fees, of any motion required to collect those service expenses, known as debts, and the court is trying to act as a debt collector. Now, that's going to be pretty interesting here in a few, because I'm going to show you a financial document I got from your very court clerk. Now, we're not going to read the rest of that because it's pretty simple. What was it? E? Serving an individual within a judicial district of the United States, unless federal law provides otherwise, an individual other than a minor, an incompetent person, or a person whose waiver has been filed may be served in a judicial district of the United States by following state law for serving summons in an action brought in courts of general jurisdiction. It's interesting that the individual, through the enumeration at birth, establishes the state's vital statistics jurisdiction for each individual born and presumed to be a resident at enumeration at birth under Federal Code 19 U.S.C. 81-0 that says no person shall reside within the zone except federal, state, or municipal officers or agents whose resident presence is deemed necessary by the board. And the zone is the federal trade zone under which your county operates, giving authority to municipalities to issue those municipal bonds. It's an interesting case when my resident presence has never been deemed necessary. I am not a federal, state, or municipal officer or agent, and it cannot be presumed. It must be deemed necessary by the board. The board is the Secretary of Commerce as the executive chair and the Secretary of Treasury, and you have no decision in that. None. I told you I am not qualified. According to Iowa code, a resident is determined by income tax purposes. I have had no job for 7 years. I've had no license, no identification to get a job. I have no bank account for the last 7 years. Your minimum state contacts are kind of screwed. So let's take a look at the next one. This is the juror questionnaire from the Iowa Judicial Branch. Administrating justice under the law equally to all persons. And it says Iowa citizens who receive a summons for jury service should complete a juror questionnaire and return it to the court within 10 days. Even though they're supposed to give you 30. Now, Iowa law says 10 days. From receipt of the summons for qualification determination. For qualification determination. See, now they're admitting that they're not sending a complaint, that the summons is for qualification determination. Completing the juror questionnaire accurately will help the court determine if you are qualified to serve as a juror. So let's go to the first question. It says no automatic excuses from jury duty. There are no automatic exclusions or excusals from jury duty. If you are summoned, you must serve on jury duty unless you are disqualified or excused by the court for one of the following reasons. You are not a citizen of the United States. You are under 18 years of age. You are not a resident of the county that summoned you for service. I guarantee you, in legal theory, if the United States has no birth registration and that the United States citizenship is merely a conference of nationality, granting a United States citizen person for use, then I guarantee you I am not a United States citizen. And you are not a resident of the county that summoned you for service. As that federal and state code exemplifies, there are certain duties, obligations, or responsibilities that one of those residents must be able to take upon. And therefore, you cannot be a minor. You have to be of 18 years of age. And when that resident determination was made at the state level, it was upon enumeration at birth, saying that that record is a resident, and that I was, through education and indoctrination, propaganda, and everything else, presumptions, presumed to be a resident, and thought I was a resident for many years. However, upon my research and discovery, I am not. And again, I told you, I'm not qualified. I'm not qualified for any administration. Again, I'll restate the express living trust of the living word, of the living will that I constantly affirm as his faithful sayings, knowing that he who believed in God be careful to maintain good works. These are profitable unto men. So at the state's expense, to sustain the state's budget, I urge you to stop this insanity, Andrea Dreyer. You are not able to communicate in English. I asked you, Andrea Dreyer, if you understand English. Much like Joseph Moodhart asked me 7 years ago in that pretrial if I understood English, and I vehemently, in my belligerent state, looked at him and said, yes. I've come to realize how little I understood the English language in its artful ways. I've come to a greater comprehension of what it is, and it is a beautiful thing. Please use it correctly. You have a permanent mental or physical disability that would affect your ability to serve. At 18 years of age, I was qualified as unfit for military service. I'd like to make it a very important point here, Andrea Dreyer. Like I said earlier, the Global Postal Trust Services that these things operate under. In every inland or every post office is known as an inland marine installation. And I can pull that information up for you too. That comes directly from the Marine Corps headquarters. See, it's the Coast Guard that regulates all maritime law inland through the inland waterways. I've come to learn this through my research, and I comprehend exactly what's going on, Andrea. Please quit playing games. You have no right to administrate in a probate estate anything that has to do with me and the estate of Jesus Christ that I follow. For I am in this world, but not of this world. I am itinerant. I am not a resident. I travel everywhere I go, teaching and ministering the word of the gospel. For before I was formed in the belly, it is he that knew me. And before I was cast from the womb, he sanctified me and ordained me a prophet unto the nations. And no nation's ordinances can sanction that word. Please, I urge you to rethink your decisions and your orders as it regards anything to do with me. I'm a good man. I speak truth. And I'm not under your administration. The courts of probate have no jurisdiction over the man or over the estate of a person who is in fact alive, and my estate encompasses all real and personal effects. I grant the repentance for all the things that I've done wrong. I acknowledge that I shouldn't have been entering the data elements that I did. And it's time to correct those records. You see, Andrea, as I said, I have a document that I got from your very own clerk. This document shows on its face material facts in evidence that there were conversions of the data elements that I gave on this side of the counter by that clerk or whoever else does that stuff on that side of the counter. And what they did was they took the last name that I gave them, Little, and the social security number on file with its dashes, and they converted both. They converted the last name, Andrea, to a firm name, Litt, and they converted the social security number to the obligor number without the dashes. I have never once, through the indoctrination, propaganda, education, subliminal messaging, whatever's been going on in this life through this English language that is so artful and deceitful, I have never once spelled my last name and forgot the last two letters. I have never once used the social security number without dashes. I hope you're paying attention, Andrea. I'm not disputing anything. I'm agreeing with the facts on the record and how they play out. I did things wrong. Other people are doing things wrong. It's time for full acquittance and discharge to reconcile these records at the states to sustain the state and federal budget. It's time to quit issuing false debts. I can contact the states or the state secretary and have a UCC 11 filed to find out if there's any valid claim of debt against this name and number. And I assure you they're going to say no. I can contact the Treasury Offset Program and again ask them if there's any debts against this name and number, and they're going to tell me no. So the debt posed here under that firm, I believe, would imply that somebody put down an investment firm for use in the court's registry investment system so that they could issue a municipal bond through the county. So I'll be seeing you soon. I'm going to have information for this video so you can take time to watch it. And I hope you do. Because Andrea, I love everyone. I'm not here to destroy your law. I'm here to fulfill the law. And that law says, owe no man anything but to love one another. For if you've loved one another, you have fulfilled the law. Andrea, I'm asking you to step up because you look kind of foolish now. That's all I got, folks. I hope you're paying attention, and may God bless you. I love you, but I don't give a rat's ass whether you love me back. Love him, cherish him, follow the way, and profit the true gospel unto the nations. You are not the nation's children. The nation is not your father. There is but one Father which art in heaven. Hallowed be thy name. And he will lead you not into temptation, but deliver you from this evil. Learn the truth so you can do those good works. Following his faithful sayings of his will, constantly affirming them, so that he that has believed in God, be careful to maintain those good works. Hallelujah. Have a good night.